Yeah, hello guys. So today we're going to be talking about wills and codicil, and it's basically going to be part one. This is on the property law practice, and it's a very important part because at the Nigerian law school, this question normally comes out in the exam, and it's important for students to have a full and clear understanding of what this means and also understand how to answer the questions. Now, a will has been defined as the expression by a person of wishes intends to take effect only at his death. Unlike a disposition of property by deed, which operates at once, a will speaks from the death of a person. It remains revocable by the testator during his lifetime. It only becomes effective upon the death of the testator. A will can also be described as a testamentary document voluntarily made and executed according to law by a testator with a sound disposing mind through which he disposes of his assets, properties. Right? So these are sort of the conditions that the testator that must be fulfilled before a will can be said to be valid. It's important to understand that a will only becomes effective upon the death of the testator. That means the will cannot be read and implemented or effected whilst the testator is still alive. The maker of a will is known as a testator. You may see this in your objective, in your OBJ questions. So the maker of a will is known as a testator. When a person who makes a will dies, he is said to have died testate. Where someone dies without making a will, the person is said to have died intestate. So in both instances, the estate of the deceased, when we talk about the estate of the deceased, means his assets, his property. The estate of the deceased person is administered by personal representatives. The personal representatives of a testator are described as executors, while the personal representative of a person who dies intestate are described as administrators. And like I said before, a will takes effect when it is admitted to probate. So when someone dies testate, that is, he dies with having a will, the person who administers his estate is known as a testator. This is important for your OBJ. That is your objective questions. When the person dies intestate, that is dying without having a will, the person who administers the estate is known as an administrator. Right? Now, this is very important to understand because it is a foundation, right? The foundation of wills. Now, what are the characteristics of a will? I had earlier given the definition of a will, and from my explanation, you can easily imply what the characteristics of a valid will be. But for clarity, I'll just state the characteristics of a will. One, it must be testamentary. And what this means is that its effect commences only after the death of the maker. Two, it must be executed as provided by the applicable law. So wills are governed by laws, statutes in the relevant jurisdiction. Under Section 9 of the Wills Act of 1837 and Section 6 of the Wills Law of Lagos State, and even Section 6 of the Wills Law of laws of the former Western region in Nigeria, it is provided that a will must be executed, signed. Also, it must be voluntary, right? Evidence of undue influence is exerted on the testator to make the whole or part of the will can lead to the vitiation of the will. So where there is proof that there was some sort of cudgeling, force, or compulsion by some external forces, third parties, on the testator, that will can be invalidated. So it must be voluntarily made by the testator. 4, the testator must possess a sound disposing mind at the time of making the will. So he must have a sound mind at the time of making the will. So it must be his will, right? The will must be his will. Very important. 5, property that is subject to customary law cannot be disposed of under a will. The case of Idehe and Idehe, 1991, 6 NWLR, Part 198, Part 382, is very clear on this matter. Now, that case talks about the Benin Idiogbe principle. Now, that principle says, which has been sanctioned by the Supreme Court of Nigeria, is to the effect that the firstborn son of a deceased man is entitled to the man's Igiogbe under Benin customary law. The Igiogbe is the place, the house where the man lived and died. So that property cannot be willed out to someone else, except, of course, subject to some exemptions, like, for example, where the first son does not participate in some of the burial rites of the father. Now, when you mention wills, people are always scared. Oh, is it that the person wants to die? Why are you talking about the will? Is it yet time to die and all of that? But I'm going to set out some of the advantages of a will. Number 1, it excludes the rules of inheritance under native law and custom. That's one of the advantages of making a will. 2, a will excludes the application of statutory rules of inheritance. Right? If you want to exclude some statutory rules that may not favor you or favor your estate, you have to make a will. 3, a testator has the opportunity of choosing his personal representatives, whereas the estate of a person who dies intestate is administered by those who succeed in obtaining letters of administration in respect of the estate of the deceased. So, one of the benefits of having a will is that the testator can decide who administers his estate. But if the person dies without a will, if he dies intestate, then, whoever obtains the letter of administration might even be the deceased enemy. That person will ultimately administer the estate, and the person may not administer it the way the deceased would have wanted it to be administered. 4, the grant of letters of administration involves the additional expenses of a bond, sureties, and all of that, while the grant of probate does not. So now let me quickly make it clear. When there's a will, for it to become effective, there will be a grant of probate, right? So the will is administered to probate, right? So now, but when there is no will, the administrators will have to obtain a letter of administration. That takes a lot of process, and you have to pay some money, all of those things. But when there's a will, it's easy and straightforward. When there's no will, you have issues of making additional expenses of a bond and sureties and all of that. Another advantage of having a will is that upon the death of the last administrator, right, a fresh application for letter of administration has to be made, and this is a lengthy process. This is this is one of the things that happens where you don't have a will. If the administrator dies, another person cannot automatically take over from where the last administrator stops. Whoever is going to take over will have to apply for another letter of administration. And I just explained to you that obtaining letters of administration for an intestate, for someone who dies intestate, for the estate of someone who dies without having a will, is a lengthy process. So instead of going through all of those, it is best for the person, the deceased, whilst he was alive or whilst he's alive, to have a will, right? So that's why I have said, I will also say that the executors of the last surviving executor can complete the winding up of the estate of a testator. So there's no break in the chain of executorship. That is in the case of someone who has a will. Then the next advantage is that an executor has authority to act as from death and even before the issue of probate. He can do certain things on behalf of the estate. A prospective administrator, on the other hand, has no capacity to act until letters of administration are granted. Another advantage is that a testator may, by his will, appoint a guardian for his minor children, right? And can also give directions as to the disposal of his remains, as to how he intends to be buried and all of that. Now, what are the sources of the laws of wills? Now, one of it is the received law on wills, and that is the Wills Act of 1837 and the Wills Amendment Act of 1852, which apply as a statute of general application. Now, these statutes have remained virtually untouched in Nigeria, but in England they've had several amendments over the time, right? And the current law in England is the Wills of Wills is in England. It's not same as the current one we have in Nigeria, right? Aside the Wills Act of 1837, which is a statute of general application, we also have the wills law of the various states of the Federation. At least we know of the wills law of Lagos State, Cap 194, Laws of Lagos State, 1994. We also have the Wills Edicts, 1990, of Oyo State, the wills law of the old western region of Nigeria. So each state have their wills law. Then another sources of the law of wills is the High Court civil procedural rules of the respective states. So the civil procedural rules of the states will typically provide for instances where you want to admit a will to probate, and instances and provisions for how you obtain letters of administration and all of that. Then we also have case law, right? Judicial precedents. Now this is made up of common law principles, rules of equity, and the interpretation of statutes on wills, right? So certain areas of the law of wills are governed entirely by case law. One of such area is the republication of wills, which is governed mostly by English case law. In the next discussion, we'll talk about what republication of will entails, right? So now we also, to conclude, I'll also talk about, before I conclude, types of wills. For the types of wills, we have customary wills, statutory wills, non-cupative wills, holograph wills, mutual wills, joint will, privileged will. These are the types of wills, and it is important you remember them for the purpose of your exam, and of course post-call for the purpose of practice. Now, the next point I'll be talking about is testamentary capacity, and there are two components: age and mental capacity. The age is 21 years under the Wills Act, right? The Wills Act of 1837, the age of where you have capacity to make a will is 21 years, and that is under Section 7 of the Wills Act. Under the Wills Law of Lagos State, Section 3 provides that the age of testamentary capacity is 18 years, right? So an infant lacks the capacity to make a will except for privileged wills, which is one of the types of wills I just mentioned earlier. So remember this: under Section 7 of the Wills Act of 1837, the testamentary capacity, the age in terms of the age, is 21 years. Under Section 3 of the Wills Law of Lagos State, and in most states, it is 18 years. Now, you also have cases where blind persons want to make wills. Can blind persons make wills validly? Do they have capacity? The answer is yes. And the case on point is Inseetful versus Christian, 13 West African Court of Waka 345. Can a blind person make a will? Do blind people have capacity to make a will? The answer is yes. What about illiterates? Yes. What about mentally disabled persons? The answer is no. Now, for people who are mentally incapacitated, because the test for the validity or capacity in this instance is sound disposing mind and memory, the testator must have a sound disposing mind at the time he gave instructions and the time of executing the will. right? At the time of giving the instructions and the time of execution. So there's some persons who are mad or mentally unstable, but they have lucid period. So if the will was made during that lucid period, or if it can be shown or proven that it was made during that lucid period, then by all means it will be valid. But generally, those who are mentally insane are incapable of making a will, except it can be shown that at the time that person made the will, the person the person had sound disposing mind at the time he gave the instructions and at the time he executed the will. You can look at the case of Banks and Goodfellow. The person must also understand the nature of the act of making a will and its legal effects. The person must also know the extent of his property which he wants to dispose of. The person must also have a recollection of the objectives of his bounty. All right, so these are very, very important areas that the person who intends to make a will must understand. Now, the next point we'll be making after in the next in part 2 of this video, we're going to be talking about testamentary intentions. We start from there and then we'll go down and talk more about wills and codicils. I hope this was helpful. Drop your comments, ask your questions in the video below in the comment section. Like this video and please subscribe to this channel. We're committed to your success. You can also share with your friends so that they can also learn. Thank you.